So hello, everyone. My name is Sarah Bessel, and I am the Deputy Director of the Human Trafficking Legal Center. Welcome to another installment of our series, Voices from the Litigation Frontline. And today we are thrilled to be joined by Doug MacLean, President and Executive Director of Justice Without Borders, a regional nonprofit in Southeast Asia that helps migrant worker victims of labor exploitation and human trafficking seek compensation against their abusers, even after they return home. And as an expert in both international and domestic laws, Doug leads professional teams in Hong Kong, Singapore, Indonesia, and the Philippines to secure landmark victories in migrant worker exploitation cases. He is here today to discuss best practices around cross-border civil litigation. Doug, welcome. We're so excited to have you, and the floor is yours, and I will hand the screen share over to you.
Oh, wonderful. Sarah, thank you so much for that warm introduction. And also my thanks to the Human Trafficking Legal Center for hosting me. I've known the founder, oh dear Lord, this will be revealing my age, since about 2005. So it's nice to come full circle here on the other side of the globe. To everybody who has joined, welcome and thank you for coming to my presentation. For those of you in the United States who are up very early, I am going to attempt to keep you awake and entertained for the next 25 to 30 minutes. Let me attempt the impossible and get share screen right the first time, which I think I did. Yeah?
Correct. You are ready to go.
Oh my gosh, brilliant. Okay, folks, I'm going to dive right in since time is short. Let's talk about today's talk first. This is the outline of what I'm going to be going through over the course of my talk here in about 20 to 25 minutes. Okay, let me start with the who and where we are. So I am actually talking to you from Singapore right now. You can tell by the color of my skin and my American accent that I am not from here. I'm a white guy from the United States. I have been in East and Southeast Asia for about the last 12 years, about 12 years in total. And I'm the founder of this organization. Justice Without Borders has been around since the end of 2013. And we focus on just one thing, which is access to civil compensation for victims of labor trafficking, or human trafficking and labor exploitation, rather. We work in very specific locations. And as all of us know, when we're talking about labor migration and legal issues, place is very important because legal systems will be different. So let me take you on a whirlwind tour of our neighborhood. It looks like I will probably have to share a different screen. So allow me to do that. New share. And we are going to go over to this screen. You folks should be able to see a screen of Google Maps right now. Sarah, is this coming up?
Yes, it is coming through.
Oh, perfect. Okay. So with apologies to people who are from this region, I just want to situate things for everybody so they really have a sense of where we're working. The little red dot down here is Singapore. And if we zoom out quite a bit, we start getting the massive landmass of Indonesia. Up here, we have the Philippines, and up a little bit further, you have the little dot of Hong Kong. So we are dealing with two destinations, namely the city of Hong Kong and the country of Singapore. Between them, they draw about 620,000 domestic workers from the Philippines from all over the Philippines, and from Indonesia. And over in Indonesia, they're really coming mostly from the island of Java, southern Sumatra, and that's about it. To give you a sense of distance, going from Jakarta to Singapore is probably about a 90-minute flight, so very, very close. Singapore to Philippines is about 2.5 to 3 hours. And then Hong Kong to the Philippines is about 90 minutes. Hong Kong down to Indonesia, 5 hours. So if we were doing all this work in the United States, you would see flight paths that actually wouldn't leave my home country. So this gives you a sense of how close things are. With the domestic workers, aside from the 620,000 who are there, there's probably another 300,000 to 500,000 who have since returned home to the Philippines and Indonesia, who are still within the limitations period of bringing a claim. So we see our constituent population as somewhere in the neighborhood of about 1 million people. Okay, let me stop that share And then let me go back to my PowerPoint presentation. Okay, so we've got this, and let me pull my guide up here so I can follow. So that gives you a bit of context geographically. Let me speak very quickly about the legal context as well, because depending on where you're doing cross-border civil litigation, you will have a different experience. Our experience is in 2 former British colonies. So already we are talking about common law jurisdictions, relatively high rule of law. Also more or less islands. So we don't have the porous border problem that you might see between, say, Indonesia and Malaysia, or say Cambodia and Thailand, or other parts of the world, honestly. So our particular context has fewer people who are entering countries undocumented on the destination side. Mind you, for both Indonesia and the Philippines, there are documentation requirements to go be a migrant worker. So some do go through undocumented channels. You have these very interesting situations where they're quite fine and legal in the, or documented in the host countries, but they are considered undocumented back home. Final point on our context, Indonesia and the Philippines have fairly strong civil societies, and they have fairly comprehensive laws on migrant labor. Philippines much more so. They've been a leader in migrant labor issues for quite some time. Indonesia looks to them kind of as, following the lead. So Indonesia is still developing theirs, but compared to other countries in the region, it is relatively developed. So that's what we're looking at. I'll get more into specific challenges later, but if you're working in a context where there are porous borders, a lot of people who are entirely undocumented, some of this will be less on point. I'm used to talking to diverse audiences about the work we do. So throughout, I'm going to try and tie what we're doing more towards a general concept of cross-border civil litigation, and then just see, how far your mileage goes with what I'm talking about. Okay, so let me start with just a couple of case studies so you have a sense of the people that we're helping and the experiences they're going through. I'm going to go through 2, one for Singapore, one for Hong Kong. We'll start with Nisa. All names have been changed to protect their privacy. So she started in Singapore. She didn't stay very long before she started suffering both physical and verbal abuse. And then on top of that, she was injured on the job, by the dog. And unfortunately, the employers did not pay her medical expenses like they're required to by law. In fact, she went untreated for a number of months and suffered further injury as a result. She basically had to quit her job and go home. When she was trying to decide whether to go home or not, things got particularly bad for her, to the point that she reported she was contemplating suicide at the time. Like a lot of migrant workers, she had family obligations back home. She had not paid off her agency fees yet, so going home would leave her even deeper in debt. And so what happened was she went home, and then we got her case over in Indonesia. So we had a local partner over in Indonesia who helped Nisa actually get the medical treatment that she needed. They contacted us, and by the time we got to her case, she had thankfully gotten the treatment, she had healed, and she had to go back to work. And so she then migrated to neighboring Malaysia to continue work as a domestic worker. So this case also encapsulates how cases of civil litigation might not just be 2 countries, it can be multiple countries, particularly if people are mobile. For those of you who have done seafarer cases, this is obviously something you know quite well about. But this is a factor in a lot of the cases that we deal with. The good news was that we did not have to go to court. We were able to seek a settlement. So our particular work was about identifying her claims, identifying her evidence, finding a liaison in Malaysia, and having a pro bono lawyer in Singapore to carry out the case. The employer was so shocked that the client found a lawyer, and they were so worried about their reputation publicly that they wanted to settle pretty quickly. And so thankfully we were able to secure funding, or secure settlement rather, and get it safely sent home to her family over in Indonesia. Taking care, of course, that it was going to the bank account she truly wanted it to, because it was in the husband's name. So that's one. So this is one of the content-related cases where we're dealing with multiple countries. More on a logistical focus for the second case, so Jocelyn. This case has actually now been reported in the public. So if you go look some of the details up in the South China Morning Post in Hong Kong, you'll find it. So Jocelyn had been in Hong Kong. She'd been physically abused and dismissed unfairly. She unfortunately had a mother who came down with a pretty bad illness. So she had been dismissed, had started her case at the labor tribunal, which is really where a lot of the employment claims happen. And then suddenly she had to go home. And this is not uncommon. And unfortunately, the labor tribunal does not allow lawyers to represent. You have to be there, or at best you can get a labor union representative, this individual in the middle, to be there with you, but really not to act like a legal representative. The thing is, however, in Hong Kong law, it's actually possible to request to any level of the courts to conduct your case via video, basically the way I'm talking to you right now. Problem was that nobody had ever made that application at the labor tribunal up until that point. So we, with our partners, went forward and submitted the application. It was rejected. And we had to appeal all the way to the high court, sort of like the appellate court in the United States. And thankfully, the appellate court said, yes, she does have a right to request this. Here are the factors for the labor tribunal to test upon. And they remanded it back down to the labor tribunal. And thankfully, the following labor tribunal hearing was successful. So we had our very first use of video link from the Philippines for this client who had to go back home and take care of her family. And the good news is that because it was a high court decision, it was a precedent that goes, across the entire city. So this impacts workers who are both there and workers who have returned already, who might still have a claim at the labor tribunal. So these two cases together, Nisa and Jocelyn's, show both some of the abuse that workers can face and some of the logistical issues that can really be the reason why workers are unable to pursue justice, and basically where we're starting to step in. Let me talk to you then quickly. I'll go through some of these slides rather fast about the overall cross-border issues that we are tackling and why we are approaching things the way we are. I'll go through these fast. East and Southeast Asia, about 50 billion is stolen from migrant workers, just in the worst forms of exploitation. This does not account for like overcharging of agency fees or injuries that are uncompensated or abuse that's uncompensated. This is closer to labor trafficking. So the actual amount stolen from workers is quite a lot higher, multiple times higher. The thing is, even in our small context of Singapore and Hong Kong, the amount of wages that workers are generating is enough to become a very tempting target for those who would exploit workers, whether they're employers or their employment agencies on the home or host country side. These numbers are obviously a lot bigger when you get to bigger jurisdictions like Malaysia or even Thailand for that matter. This you folks will be quite familiar with as to what sort of injuries can happen in the long term, particularly for migrant workers in our region. For the Philippines and even Indonesia, remittances are a big part of the economy. For Philippines, can be upwards of 10%. For Indonesia, it's 1% overall, but certain localities, it can be 10 up to 20% of their local GDP. So as you can see with our language here, we're very much approaching this from an economic perspective, that exploitation costs workers and that cost also causes suffering. And this also starts to build the reason for why one would want to go after people who've exploited workers in civil court aside from criminal court. Because my own personal research from about 10 years ago at the UN over in Bangkok was that after their health and their safety, workers really do need compensation in order to be made whole again and not to fall into a cycle of re-victimization. The problem, now we'll start talking about some of the problems. Even if you're lucky enough to be working in a country that has a fairly robust legal system, say like Singapore and Hong Kong, most of the laws, if they do protect migrant workers, are very much domestically focused. They don't really anticipate people coming and going, mostly because in the commercial world, the law doesn't really have to think about that quite as much. people of wealth or corporations just hire lawyers wherever they happen to be, and the lawyers take care of everything. Not so easy for migrant workers who don't have the money to hire lawyers. The other issue, of course, is that, well, where there are free legal services, those free legal services are usually run by very local entities, both at home and abroad. So what you end up getting, of course, are these different islands of aid that don't really reflect the actual mobility of the worker. So somebody has a problem, say, over in Singapore, they go home, the people in the home countryside can't help. And for that matter, if they've been cheated or overcharged or otherwise exploited in Indonesia, there's not a lot that the aid agencies in Singapore can do while that person is still working over in Singapore. So it's really addressing this gap, which is what we're about. Because the ultimate problem, particularly in the Singapore and Hong Kong context, is, look, migrant workers are not able to stay long enough to pursue their case, or it becomes too expensive to do so. They go home, case drops, which of course also creates a culture of impunity. And people here know that they can exploit a worker, fire them, send them home, and they largely avoid repercussion. Now, we're trying to change that. So let me talk to you a bit about how we're approaching this and really where we've gone from sort of theory to actual practice in the last few years. First of all, this is the ultimate goal for us. Like, our ideal is that if a migrant worker faces any sort of problem in the course of their migration, they can go and seek help for it. And if it's a legal solution that's required, doesn't matter where they are. Like, that's what exists in the corporate world. To some extent, that exists, say, with international transport workers with that particular union, or to some extent in the refugee world. But at least in our particular region here in Southeast Asia, that just doesn't exist. But that's what we're trying to make in the long term. Just a heads up that JWB is not focused only on human trafficking. We are attacking the entire spectrum of exploitation. You deal with lesser forms of exploitation, you can often head off worse forms like human trafficking. And we're very much aligned with the ILO in how they approach these things. But what we're trying to do, really at a big level, is to attempt to do these cross-border cases, understand what works and what doesn't work, not just with one or two cases, but really building a critical mass of cases so that we understand how to make cross-border litigation efficient, effective, and affordable. And then ultimately connecting organizations on the home and host country side so that we do create these international lifelines to legal aid. So again, the overall concept is it shouldn't matter where a worker is. If they can get to local assistance, that local assistance can get them help, even if it's a couple of hops away. So the way we've been approaching this, if we're going for efficient, effective, and affordable, the first way that we're working on this is really building networks. We have a lot of cooperating organizations in both the host and the home countries. And these include NGOs, some university legal faculty, as well as some government agencies. The idea in the long term is that, look, one organization is not going to be able to handle this even in relatively small contexts like ours. Particularly given how big Indonesia and the Philippines are geographically, those 620,000 workers who are going home really need to be able to talk to somebody in their own community. So part of our work, honestly, is getting with those frontline organizations that help migrant workers and providing them our experiences in cross-border litigation so that they're able to do what they're able to do with their capacity to help a worker pursue their claim even after they go home. The second part, and frankly, sort of the more upfront part, is the knowledge. This part really applies, I think, to almost any context that we're dealing with in terms of migrant workers, whether you're in Africa, US, or Europe. Understanding what's possible on paper and then what's possible in practice and seeing how far you can move the needle. This works very well in countries that have, a decent level of rule of law. Does not work well at all in countries where the rule of law still needs significant development. So for example, in countries, say like in the Middle East, there'll be some where the laws are set up that are really against migrant workers. And what we're doing here, knowledge of the law wouldn't really help. But where it does help, it does start to help us identify, well, what's there on paper that we might be able to use for migrant workers' purposes. And then the final piece, of course, is the know-how. Cross-border civil litigation in our region is quite new. So part of it is experience building, really building the cases in practice, and doing that alongside our frontline NGO partners, as well as our pro bono law firm partners. I'm going to go through a couple of slides that have some statistics. I'm going to talk more about some of the features of our work context that may or may not apply to you. So when we're talking about some of these numbers, you see pro bono hours. In Hong Kong and Singapore, nonprofit organizations are actually not allowed to practice law. Our heads of office and our legal officers are usually, always actually, legally trained and usually licensed, but they're not able to use their license while they're with us. So we have a particular need to depend upon pro bono legal services to deliver our services. To the extent that you're in a context where you can have lawyers on staff and actually go to court and practice law, then you may not need the pro bono hours quite as much. The other bit, when we're talking about the strategic guides that we have built, almost all of these are really for people on the front lines to use. We do shy away from more theoretical research. It is all practical research that we're doing. We find this because laws in our particular regions, even Singapore and Hong Kong, that do a lot of commercial litigation, there's very little judicial experience in dealing with migrant worker issues at a level above, say, the labor tribunal. So having these materials out helps lawyers and can also guide judges to the extent that they peruse these materials. I should also say that in the last 4 years plus, give or take, we've screened some number of cases, but really we are about impact litigation at this point. So our Hong Kong and Singapore offices together have 32 live matters, and we've got our case teams between the two are about 4 staff members. So it is actually relatively busy for our size, but the cases that we're looking at are so often including things of first impression that we're dealing first with a smaller number of cases to create bigger impact. That's where we stand now. Obviously, our long-term goal is more of a critical mass of cases, but that happens not only through us, but through cooperating NGOs and law firms who would be bringing additional cases in parallel. Finally, the amounts of money that we are securing for clients mean a lot in their home country contexts. From the host country's perspective, it could amount to just a couple, 3 months of a local salary. But because salaries are so much lower for migrant workers, it doesn't look like a lot from this perspective. And that actually helps us a lot of times when it comes to negotiations, because it's often a lot more expensive for the other side to engage a lawyer when they can pay to resolve the problem. Talked about who we are working with here. I see I got about 3 or so minutes left. So let me stop here really quickly because I've been going fast. So the quick recap is that what we're looking to do is really build the experience of cross-border civil litigation, share that with our partners, usually in a clinic or mentorship sort of situation, and get them to a point where they are independently doing this work in parallel with us. And that our particular specialty is really pushing the envelope for what is possible in terms of making cross-border claims. We don't go to court all that often. We have been settling more and more, but those settlements are also incredibly helpful to the clients, and they teach us a lot about what are some of the logistical and even what are some of the procedural problems. Those few cases that do go to court and get to decision are generally impactful. Now, let's talk about the challenges and opportunities in our work, because there's obviously a lot going on, and a lot of this is difficult. The first part, of course, is that, like I said, there's not a lot of organizations in our context that are already doing this cross-border work. Even when we're talking about pro bono law firms, if they don't have a local presence in Indonesia or the Philippines, they're often learning how to do this work. And even if they do, they're probably learning how to do cases for migrant workers rather than the commercial matters that they're used to doing. The court systems usually do not see migrant workers. As I said earlier, a lot of times they don't even see migrant worker cases because the workers don't bring their cases. So there's not a lot of judicial experience either. And then finally, with our nonprofit partners, they are very good at dealing with their local issues in their own countries, but they haven't had the time, expertise, or capacity just yet to work on a case-by-case matter with counterparts in other countries. So a lot of our work, in addition to generating experience, is also building up this infrastructure. And as I mentioned, the experience, of course. The client challenges will not be a surprise to anybody who has worked with high-need clients, and migrant workers are high-need clients. And by that, I mean they're mobile, they don't have a background necessarily in legal matters. They often come from places where the law happens to them and does not help them. They may be facing a lot of family needs at home, and then also a lot of pressures to find another job. And I'm not going to say there's an educational background issue, because truly our clients range from people who did have to go to work at a very young age to people who have a master's degree but make more money as a domestic worker in Singapore, for example. The cultural background, though, can kind of come in the way, because how the law works in Singapore and Hong Kong is very different from how the law works over in Indonesia and the Philippines. The other big issue, of course, is that if we're going after an employment agency that has really wronged a migrant worker, they may send thugs to the worker's house or to their family. There are security issues to deal with. Domestic legal regimes can have gaps in them, and sometimes gaps between the home and the host country. So, for example, if you're trying to get from Indonesia over to Singapore, laws on what agencies in Indonesia can charge you are very different from the laws on what agencies in Singapore can charge you. And these legal systems have never really been matched up. So even the bilateral legal regimes are actually not consistent. The biggest one, and this is a long-term thing, is that international legal regimes, of course, are not really present. We don't have anything like, the Refugee Convention. We do have, obviously, a treaty on the rights of migrants and their families, but no destination country in our region has signed it. And so it's more out there for the future rather than having been ratified and implemented locally. So you're really dealing with a patchwork of legal regimes, and you're trying to navigate the client across them and try and fulfill their rights as best as you can between them. I'll end with this. Our update over the last year or so under COVID-19 has been that we have gotten even busier than before. Our case inquiries went way up as migrant workers were facing worse and worse conditions. We deal specifically with domestic workers who, under Hong Kong and Singapore law, actually have to live with their employer. And what that means is that families were already facing increased stress and pressure, which led to higher domestic violence, and domestic workers were often taking the brunt of that. So we have seen more inquiries along the lines of abuse, frankly. We're also now at a point where we're waiting for flight routes to reopen within the next year and a bit. Singapore and Hong Kong, by the way, have been doing very fantastic compared to, say, like the US or Europe. Indonesia and the Philippines, not so much, but we could see a point where workers are going to be able to go home again. And even if 10% of these workers turn over, that's about 62,000 workers coming home all in one rush from Hong Kong and Singapore, not to mention all the other workers coming from the Middle East. So we're fully expecting our frontline partners in Indonesia and the Philippines to be more or less just deluged with cases. So part of our work now is getting with the partners that we do work with and getting them up to speed on, well, how do you triage cases and put them on hold so that you have preserved the evidence, but you don't have to deal with the case immediately because you've got a 2 to 6 year limitations period, and that you can just focus on the cases that need help now. Finally, and this is a very important thing, a lot of folks say, look, evidence is a key issue. In most contexts, workers just don't have much evidence. We've made a lot of progress in securing evidence in certain situations, particularly government records for those departing from their home countries, as well as medical records and actually business records in Hong Kong and Singapore, either pertaining to the worker on the medical side or to the employment agency when it comes to the business records. And this has allowed us to take some cases that really had not a shred of evidence and make them strong enough that the other side, the defendant in this case, actually settled. So that's our latest update in terms of what we've been able to push forward during COVID and what we think we're going to see going